session, I believe. And thank you for attending to this session. We're very, very honored to have you here today. So today we're having a very interesting topic, which is managing disciplinary cases in work from home culture, which our speaker for the day is Ms. Wong Keat Ching, who is no stranger to us. She's worked with us before in several conferences and seminars. Ms. Wong is a partner in Zul Rafique Partners, a legal firm, a top legal firm. Just to briefly introduce Ms. Wong Keat Ching is a partner in the employment, in industrial relations and litigation practice groups at Zul Rafique Partners. She holds a Bachelor of Arts in Law from the University of Nottingham and a Certificate of Legal Practice. She was admitted as advocate and solicitor at the High Court of Malaya in 1998. Ms. Wong has also been named as a Distinguished Practitioner 2020 by AC Law Profiles. So apart from cases involving discipline investigation of misconduct and dismissal, Ms. Wong also provides regular advice on corporate restructuring affecting employees, in particular, mergers and acquisition exercises, voluntary separation scheme, VSS, restructuring of senior management positions, establish and closure of foreign companies in Malaysia, as well as labor due diligence. Okay, without further ado, we'd like to present and leave the floor, our webinar session, to Ms. Wong. Ms. Wong, please.
Thank you very much, Vishnu. Hello, everyone. Good afternoon. First of all, ladies and gentlemen, please allow me to acknowledge and thank my colleagues, first Shazwani and Kate Hua. They are the one who did the research and prepared the slides and sorted out all the technical problems for me to be able to speak to you here today. And thank you for joining the webinar this afternoon, ladies and gentlemen, for taking your time. Okay, so you know what WFH is. This is a commonly used abbreviation. Other very commonly used abbreviations that are commonly understood now is, of course, MCO, CMCO, RMCO. And these abbreviations, I think especially MCO, if you recall, we went through about 6 weeks of MCO when the whole country, almost all businesses were in a complete lockdown. Only essential services were operating. Now that MCO period gave rise to unprecedented challenges to employers and employees. So in my presentation today, ladies and gentlemen, I would like to share with you some challenges, issues in managing disciplinary cases in the new normal, now known as WFH, or work from home, or the trending term now is WFA, work from anywhere, right? So let's have a look at the general overview of what we're going to discuss this afternoon. I will look at some issues on how to manage employees who refuse to attend at the workplace due to fear of COVID-19. What do you do if you have employees whose fears may be justified, but some others, their fears may be just exaggerated paranoia? We will look at how to manage employees who fail to provide personal information for COVID-19 tracking purposes, because a lot of employees are now working from home, working from anywhere, and then when they are required to go back to the office, there's a need for the employer to obtain declarations from them on their personal health status and their risk factors, their exposures to COVID cases, right? Then I will discuss some cases arising from work from home. And finally, I will touch on misconduct of moonlighting and how this misconduct now must be viewed differently in the new COVID-19 situation. Okay, so let's get started. Work from home or remote working is now definitely the new norm, right? And I think there was a poll just now, and a lot of people are choosing to either work from home or they don't mind working from home, right? You will find that this new norm, of course, disrupts and completely changes the way you used to handle disciplinary cases. Yeah. I think you probably need to think about this time that we are in now as BC and AC. BC is before COVID, AC is after COVID. So BC, before COVID, if you had an employee who refused to attend work, you would just simply have dealt with it by taking the usual disciplinary action for absenteeism. But now, AC, after COVID, what if the employee refuses to attend work because of fear of being infected by COVID-19, right? So depending on the circumstances, the company may take a flexible approach, right? So take this scenario, for example. If you have an employee, Encik Abu, he's 55 years old, he has diabetes, high blood pressure, he thinks he is vulnerable to the infection and he refused to attend work, right? So the company may take a flexible approach and consider alternative solutions. So what kind of alternative solutions? Are you going to offer better medical benefits so the employee feels safer that their medical expenses will be adequately covered? Or are you going to allow the employee to work in isolation? But this could be difficult if it's in a factory or plant environment. Or are you going to reduce working hours and reduce working days for this vulnerable employee? So maybe it will help to reduce the employee's exposure to people and shorten the time of exposure. Or are you going to allow a temporary change of job scope? So for example, if Abu was a receptionist, his exposure will be very high because there are lots of people coming in and out. So perhaps assign him to do clerical work or paperwork, right? So if all these alternative solutions were not successful and the employee still refuses to attend work, even when the company has complied with the SOP set by MITI or by the National Security Council, then the issue is the employee would need to prove that the workplace poses an imminent danger to the employee's health, right? So he can't just simply say that he feels that he is vulnerable and he is afraid to come to work. There has to be an imminent danger posed, right? But let's have a look at what the courts say about this employee's refusal to attend work due to an unsafe working environment. So in the case of Air Canada against Canadian Union of Public Employees, an air steward refused to work after claiming that he smelled something akin to the smell of blue cheese for the first 15 minutes before or after, before the flight and also before landing. So those of you who are familiar with blue cheese, you know what it smells a bit like gas, right? Bad gas. So the law in Canada allows for employees to refuse to work if there is a threat of danger, and the courts have laid down general points in considering whether danger exists. So these are the factors to consider whether danger really exists, right? So firstly, the likelihood that an employee will be exposed to the hazard, condition, or activity in circumstances that can reasonably be expected to cause injury. Secondly, that the exposure is capable of causing injury or illness to an employee at any time, but not necessarily every time. So this issue then now requires evidence from a health and safety expert, in this case, a health and safety expert on air contaminants, right? Third factor, the injury or illness is likely to occur before the hazard can be corrected. Fourthly, that the determination of danger cannot be based on speculation or hypothesis. Yeah, so it cannot be based on hypothesis. And fifthly, the time of occurrence of a hazard condition or activity need not be established precisely, only that the circumstances causing potential injury or illness be ascertained, and that their future occurrence is not a mere possibility. Right? So, in the Air Canada case, ladies and gentlemen, the Health and Safety Officer's investigation report was crucial. Yeah? That investigation report led the court to conclude that the evidence did not support the conclusion that the air contaminants reached such a level as to present danger to the employee. So there was, the air steward was right, there was a smell, but it was not to such a dangerous level. Actually, the investigation revealed that the smell came from the jet oil that was being used, but it was not dangerous to inhale. So that was the finding of the health and safety report. So the Air Canada case provides us some factors or points for consideration when an employee claims that the workplace is dangerous or unsafe, right? In Malaysia, we have Section 14(3) of the Employment Act, which provides that an employee may terminate his contract of service with his employer without notice where he or his dependents are immediately threatened by danger to the person by violence or disease, such as such employee did not by his contract of service undertake to run. So in our Employment Act, there's a provision for threat of danger caused by violence or disease. So that would cover your COVID-19 situation. But whether this Section 14(3) is applicable to COVID-19 begs a lot of questions, right? Firstly, is Section 14(3) only applicable when there's a positive COVID-19 case in the workplace? Otherwise, if there's no positive case, how is the employee threatened, right? By danger of the COVID-19 disease, okay? So surely a perceived risk of infection is not sufficient for the purposes of Section 14(3), right? Just like the Air Canada case, yeah? But the situation may be different, ladies and gentlemen, if the employee can prove a case where there's no positive COVID-19 cases yet in the company's premises, but perhaps the company is not following strictly certain SOP. So for example, the company doesn't strictly implement the 1 meter social distancing rule in the workplace, right? So employees are seen gathering in large numbers in the cafeteria, for example, or the pantry. So if you have a situation like that, where SOPs are not strictly enforced, then the employee may have a case to claim that there is threat by danger due to disease, okay, and that can give rise to a constructive dismissal claim. Now let's look at what is provided in our OSHA, okay. So we have Section 48(1) of the Occupational Safety and Health Act. Under Section 48(1), if the DOSH officer is of the opinion that your workplace is likely to be a danger or a serious risk to health, then the DOSH officer can serve an improvement notice to the employer to require the employer to take measures to remove the danger or rectify any defect. So that's an improvement notice that the DOSH officer can serve on the employer if there is danger at the workplace, right? Then Section 48(2), if the officer is of the opinion that the defect in subsection 1 is likely to cause immediate danger to life or property, he shall serve a prohibition notice prohibiting the use or operation of the place of work, right? So this prohibition notice is much more serious. It's actually like a stop work order for the company, right? So that is the OSHA provisions. So with this kind of provisions under our OSHA Act, it's not easy for employees to just simply claim that they don't want to come to work or return to the office after, say, the RMCO is over and due to COVID-19 fear, right? There must be a real threat of danger. And if the employer has taken steps, right, to follow all the SOPs or to remove the danger, or if the DOSH officer has checked the place of work and found it safe, then there's really no grounds for employees to refuse to come to work due to their own personal fears, right? So now, what about employees who are willing and keen to return to work, to return to the office? They too may be a risk factor if they have, of course, if they have COVID-19 symptoms, or if they have been in contact with confirmed cases, or if they have visited high-risk area, or if they have someone in their household who have returned from a country which is a high-risk area. Okay, so can an employee then refuse to provide his personal information about their COVID-19 situation? Yeah, the answer is no. They cannot refuse, right? There is a duty under Section 24 of OSHA, and Section 24 provides that it shall be the duty of every employee while at work to take reasonable care for the safety and health of himself and of other persons who may be affected by his acts or omissions at work. B, to cooperate with his employer or any other person in the discharge of any duty or requirement imposed on the employer. C, to wear or use at all times any protective equipment. So in the COVID situation, that protective equipment would probably be the mask for us normal officers. D, to comply with any instruction or measure on occupational safety and health instituted by his employer. So this paragraph 24 stroke subsection 1 subsection D, this is the one that will cover the employer's instruction to employees to fill up declaration forms concerning their health status, concerning where they have been, whether they have family members who have traveled and come back from abroad. All that kind of information can be required by the employer to be declared, and employees may well have to comply given this Section 24 subsection 1 subsection D. And if the employee refuses, then he contravenes the provisions of this section, shall be guilty of an offence and shall on conviction be liable to a fine not exceeding 1,000 ringgit or to imprisonment for a term not exceeding 3 months or to both. So it is an offence under OSHA if the employee refuses or doesn't make honest declaration. Okay, so the obligation is to disclose if they are risk factors. Employees have an obligation to disclose to their employers if they are a risk factor. Okay. The industrial court have deliberated Section 24 of the OSHA Act before. In the case of Muhammad Fadli against Malaysia Airports, the claimant committed a misconduct by driving recklessly in KLIA 2, causing an accident. That was in breach of Section 24 1A, and the industrial court upheld the dismissal. So Section 24 is the section that's been recognized by the industrial court. Right? Okay. Then next question: Can an employee refuse to give his personal information because he says it's his personal data protected under PDPA? Yeah, so because you may well be aware, ladies and gentlemen, that under the PDPA, health information is classified as sensitive personal data. And Section 40, subsection 1 of the PDPA provides that sensitive personal data requires the explicit consent of the data subject in order for the data user to collect and process such data. So can an employee say, refuse to give consent to the employer to collect information about his health status in relation to COVID-19 risk factors? The answer is no. The employee cannot refuse, right? This is because even if the employee refuses to give consent, Section 40, subsection 1, subsection B, subsection Romans 3 allows for the processing of sensitive personal data without the consent of the employee, where the processing is necessary in order to protect the vital interests of another person in a case where consent by or on behalf of the data subject has been unreasonably withheld, right? So the employer can go ahead and collect that information, health information, sensitive personal data from the employee, even without the employee's explicit consent, and process that data. So like taking the employee's temperature and all that, that is also considered personal data. But it doesn't mean, ladies and gentlemen, it doesn't mean you just go ahead and do things without their consent. Because if you read subsection Romans 3 properly, it says where the data subject has unreasonably withheld their consent. So you first have to ask for their consent, and if they unreasonably withhold their consent, then you can go ahead and collect and process their data, right? So there is a requirement under Section 40. There is a provision here under subsection 3. Okay. But of course, now with the COVID-19 situation, it's easier because even the Ministry of Health has issued guidelines, the COVID-19 management guidelines for workplaces, and there they have listed out the guidelines to encourage employers to take the temperature and record the temperature of employees regularly, employers to obtain travel declaration from employees on their travel history. Employees are also requested to alert their supervisor if they develop any symptoms of COVID-19 and all that, right? So if employees still refuse to comply, then the usual disciplinary action can be taken for breach of the company's policy on this, or the company's SOP, in line with the MOH guidelines here, right? Okay, so now let's move on to misconduct arising from work from home. This next section, work from home, ladies and gentlemen, is certainly a phenomenon that challenges the old rules about working. Work from home totally disrupts old rules about working hours, about attendance and punctuality, and work etiquette in general, right? So you may have a misconduct where an employee failed to attend a virtual meeting or online meeting, and you issue a show cause letter in your usual old way. But the employee replies and says, he says he had bad internet connection, and all morning at home he had bad internet connection and he couldn't log on properly, and he didn't want to disrupt the meeting, so he didn't log in later. And then B, he says the online meeting was recorded anyway, so he had since viewed the recording of that meeting, taken the necessary actions, follow up on what work he needed to do, right? So these two grounds both sound reasonable. A flexible employer may accept this and move on just give a note of advice to this employee to remind him to not miss another online meeting, and better inform people early if he cannot, if he's having internet connection problems or whatever. But an old school strict employer may refuse to accept this kind of excuses. He may say it's the employee's duty to make sure that his internet connection is stable for an important meeting, right? He should have set up properly and tested everything, because it was such an important meeting. He shouldn't only find out 5 minutes before the important online call that he didn't have good internet connection. And then he may say the employee cannot choose to rely on the video recording of the meeting. This is not Astro on demand, you know. You cannot choose when you want to watch the recording of the meeting at the time convenient to you. So, ladies and gentlemen, you have to decide how strict or flexible you want to be. How strict or flexible does your company want to be when it comes to this work from home culture? And this has to be made clear in the SOP for working from home, right? So, ladies and gentlemen, even though the work from home policy appears to be something that is more beneficial to employees, in reality, this may not be the case. Employees actually face many challenges when working from home or working remotely, right? Extended working hours, right? I mean, if I could see a show of hands, I'm sure a lot of you will put up your hands if I ask you, do you feel you're working longer working hours when you're working from home? Yeah, because remote employees are more likely to overwork when personal life and work are both under the same roof. It is harder to switch off. Yeah. And then the other challenge of prioritizing work. It is challenging for remote employees when you have a more flexible and free-form day. And then maybe if you're a manager managing different parts of the world, it's difficult to manage your workload and time, right? And then there's the constant temptation to watch one episode of your favorite show during your break time, or tidy up the kitchen when you're procrastinating on a project, and all of a sudden it's the end of the day and you have nothing to show for. So not everyone has the same discipline or same level of control to be able to work from home effectively. And this needs to be recognized, because it's a problem that is caused by the environment, right? Not necessarily by the attitude of the employee. Yeah. Then you have online meetings overload, calls overload. Remote working environment has turned into almost back-to-back meetings because it's just now so easy to organize an online meeting. Everyone expects you to be available anytime just because you're at home. There's no need to book a meeting room, no need to make sure people are all available. So all this brings on a lot more online meetings and calls. Another challenge is technology hiccups. Actually, this one really stresses me out, technology hiccups. Nothing makes a remote employee in fear as much as internet outage or computer breakdown or bad weather, right? So the biggest challenge for work from home is being able to rely on a stable and fast internet connection. Then you have interruptions. Yeah. I mean, the good thing about working from home is you can avoid colleagues who suddenly drop in and disrupt the work and have a chat with you. But the bad news is you will most likely have to deal with all sorts of other interruptions at home, pick up your Grab food or your online shopping, or if your in-laws suddenly drop by. And then those of you who have children, that kind of interruptions are unavoidable. But if you don't have family members at home, then the problem is converse, right? You may have cabin fever due to the lack of human interaction. You may have the opposite problem of interruptions. You may feel cabin fever because you've been cooped up at home for too long, all by yourself. And then bad health habits is of course a problem. When you are at home, it is very much easier to slip into bad eating habits. When the refrigerator is just 14 steps away from your office, how do you distance yourself from your refrigerator and stop eating all the time, right? So my point here, ladies and gentlemen, is that employees face all sorts of challenges working from home. And when employers consider the misconduct during work from home, employers need to balance disciplinary action with understanding the kinds of challenges that employees face during work from home. Yeah, I think this is an important new thing to think about because there is a need to balance discipline and productivity with flexibility and understanding, right? So those are the new things to think about. Okay, so now let's look at some trending, I call this trending misconduct arising from work from home, all right? So you have, let's start with insubordination, okay? The failure to deliver or complete task and not being available, not contactable during working hours. According to Workplace Trends and Virgin Plus Survey 2019, they found that 2/3 of employees globally who work remotely are either always or very often they are not engaged. In 2009, IBM reported that 40% of its 286,000 employees in 173 countries were working remotely. That policy allowed IBM to sell off its offices and gain almost USD 2 billion. However, in March 2017, IBM, together with a few other companies in the US like Yahoo, they pulled back thousands of employees back into the office because their profits had fallen, right? So there is a issue about productivity there. The research that is done here also shows that remote workers are not as productive as when they are on site, right? So I think it may be necessary now, ladies and gentlemen, to think about the issue of insubordination or lack of productivity from the context of the new working environment that employees have been forced to adapt to, right? I mean, the level of concentration, the level of engagement when one is working from home is bound to be affected compared to when one is sitting in the office. And then not every employee has the luxury of redecorating or renovating their office or rather a room in their house to turn it into an office space, right? I mean, I remember when the MCO started, I had to buy a new chair to be able to have a comfortable working chair at home to work properly. So you can imagine all the other things that come along with having to work from home. And then the level of concentration is also challenging. I mean, if you can observe, those of you who have children at home doing their Zoom classes or Google Classrooms, it can be the most boring thing in the world for a kid to have to sit through a monotonous lecture and listen to a teacher through a video camera, right? So the problem is not the kid, right? It's the environment. So similarly, employees may face this kind of challenges when it comes to working from home and not having the same productivity level that you would expect when they're working in the office. Misuse of companies' resources for personal use. In April 2020, Kaspersky surveyed more than 6,000 people working from home across the globe about their online habits. Nearly 20% said that they use the device provided by their employer to watch porn. So I can imagine the number will be much higher for watching Korean drama, right? What's next? Sexual harassment. Now, how is this misconduct on the rise, even during lockdown? It comes from receiving sex jokes, receiving unwanted photos, videos, audio recordings that are made through various digital platforms, various messaging apps and conference apps and emails, right? So the need to monitor the use of digital platforms in the work environment is now increased because the lines are blurred between personal communication and professional communication. Yeah. Being under the influence of alcohol or drugs, this is certainly a misconduct that's very difficult to control when employees are not physically present in the office, right? It's also a misconduct that is difficult to prove because unless you immediately haul in the employee and ask him to go through a urine test or a breathalyzer test, it's really very difficult to, like now when I'm talking to you, how would you know whether I've been taking alcohol or being under the influence? It's difficult, right? Unless somebody comes and do a test on me right now. But I'm very sober this afternoon, don't worry. Just a bit thirsty. I'll just take a sip of water. Okay. Okay, so now we move on to another misconduct that I would like to touch on. The misconduct of moonlighting. Okay. So I think this misconduct of moonlighting is one that has to be dealt with differently, BC and AC, before COVID and after COVID, right? Because as you know, many employers have implemented cost-cutting measures in view of the severe business downturn caused by COVID-19, right? So as a result, many employees had to consent to reducing working hours, reduce working days, reduce salary, reduce allowances and benefits. And then it's almost a foregone conclusion that a lot of employees will not receive discretionary bonus or salary increment come the end of this year. So it's all very bleak for employees, and employees may need to supplement their income in order to make ends meet. So while working from home, can your employees supplement their income by having a business in baking cookies or sourdough bread or whatever to sell on Facebook? Or can your employees work from home, who are working from home, can they conduct Zoom yoga or Zumba classes to supplement their income? And then they put this up on Instagram. So in the past, ladies and gentlemen, zaman before COVID, right? The law on moonlighting misconduct tells us that the court frowns upon this kind of misconduct, right? It's very clear. In the case of Supaya Velasamy against NSTP, the claimant, he claimed constructive dismissal when the company cut his salary and rejected his application for annual leave, amongst a lot of other things. The company justified its actions by showing evidence that on many days that the employee, Mr. Supaya, was not at work, he was actually doing freelance work for another company, doing proofreading work, right? So the court, of course, rejected the constructive dismissal claim and the court held that moonlighting whilst on casual or medical leave had been unabashed truancy. So that is not something that the court would allow, right? Moonlighting is akin to truancy. Swiss Garden is another case where the Court of Appeal upheld the dismissal of employees who were found to be working for another employer, right? So that's very straightforward. But of course, the cases of Supaya and Swiss Garden, ladies and gentlemen, these are based on very different facts than our current circumstances, where employees are pressed to make additional side income. Especially if, like I said, if the company has implemented cost-cutting measures and employees have had to take salary cuts and all that, right? So I would hesitate to advise the dismissal of an employee who is moonlighting due to financial difficulties during the COVID-19 situation. Okay. I think I would urge companies to come up with clear policies to deal with moonlighting situation, so that there are clear guidelines that employees can participate in activities to generate side income, provided some rules are being followed. So for example, you can make it clear in your SOP or in your guidelines for moonlighting that the side business cannot conflict with the business of the company, obviously. Or number two, the side business has to be done after working hours. Even though they're working from home, it has to be after the official working hours. Or the side business cannot affect the image of the company. So the type of business that they are doing, the employees are doing, you also want to set some guidelines there, right? So that's my take on this moonlighting issue, ladies and gentlemen. The last slide here I have of my presentation, these are just some statistics on moonlighting. So you can see that a lot of people are doing part-time jobs, especially doing Grab driving and all that, right? So that is on moonlighting. But now let me move to my next slide. Okay. So this last section, I'd like to share with you about monitoring employee performance, right? When they are working from home. Of course, it's non-exhaustive list and just best practices in monitoring employees who are working from home. I think firstly, ladies and gentlemen, it is important to reinforce the message that performance is important, right? Performance is still important, even though everyone is either working from home or facing a situation where the company is, the business has reduced. But the message has to be put forward that performance is important. The message has to be put forward that everyone's, every ounce of effort matters to put the company back into business, right? So that message has to come out loud and clear, even for employees who are working from home. There's a need to boost morale. There's a need to communicate a lot more because you don't see your staff as much, right? And then secondly, of course, you should set some ground rules to put in place so that there's some structure to the work environment, even when they're working from home, right? So you may want to set a check-in time daily, so in place of the clock-in time, so there's a check-in time online, so that there's some sort of a roll call if that's necessary. Dress code, I think it's important because that sets the tone of the work day, even when they're working from home, right? And then whether you want your employees to submit timesheets on a daily basis, right? Rather than at the end of the month or at the end of the week, then that's too difficult to track. Okay. And the requirement to get your employees to the requirement to get your employees to put their appointments or assignments in calendar entries, right? So all these are things that you can introduce rules to put in place to better monitor employees' performances at work, right? Then thirdly, of course, is the need to regularly monitor and give feedback to your employees, because employees will feel isolated when they're not at the workplace. So the need for more regular calls or team meetings to check on their progress at work, and also their well-being, how they're coping with working from home, right? Okay, so I think I have come to the end of my presentation. Ladies and gentlemen, this last comic strip would never have been understood in the time before COVID, right? So we will do well to remember that these are very different times now after COVID, and the challenges in managing employees are also very different now. So I hope what I've shared with you this afternoon in some ways help you to realign and rethink the way we manage disciplinary cases. So that's all from me, ladies and gentlemen. I hope you found the presentation useful. So I will hand back to the host. So who is Mr. Vishnu going to come on, or someone else?
Okay, thank you very much, Ms. Wong, for a very interesting discourse on managing disciplinary issues in the work from home culture. As Ms. Wong has mentioned, this is the new norm, whereby I'd like to point out we had the initial poll question, in which case we've seen the results, and many of you seem to choose 50-50, work from home and work from office. So that seems to be the obvious choice. Yes, we like to try out both work from home and work from the office, which means that employees are more keen on flexi work schedule as the new norm, rather than work from home fully or even work from home office, which sounds rather reasonable. So, okay, as I mentioned, thank you very much. And we've come to the end of our session. Are there any questions Ms. Wong would like to address?
Yeah, are there questions? The questions are in the group chat, isn't it?
Hello.
Hello.
Hi, I just have a quick question with regards to PDPA.
Yes.
Okay, if let's say, because when we employ a particular employee, we already have their IC information, their contact number and such information when we do hiring process. So let's say in situation where we are in COVID-19, let's say the building management is requesting for all this personal information to be provided to them, simply because they want to do a health monitoring or tracking of these employees. So in these circumstances, right, since we as an employer, we already have this information when we hire these employees, do we still need to request for their consent for the sharing of this information with the building management, example?
Yeah, I think you need to be careful, because the PDPA, the notice that you gave to your employees when you hire them, you have to tell them what is the purpose of collecting that information, right? So now, after this COVID-19 situation, the purpose of giving this information to, as you said, the building management is different. So your employees should be notified that now there is this new purpose of providing this information to the building management, because the PDPA Section 7 notice requires you to inform employees the purpose for which you are collecting that information from them, right? So I think it's better to let the employees know that their personal information is being processed for this new purpose now, which is the COVID-19 situation. Okay?
Is notification sufficient or a consent is also required?
I think the notification with a caveat that if you don't consent, then please notify us, that would be the best.
Okay, thank you.
Okay.
So, okay, good. Any other further questions? Anyone of you would like to pose to Ms. Wong?
There's one question asking, create study WhatsApp group and add the lecturer number. Is it violate the PDPA?
When you create a study WhatsApp group and add the lecturer's number, does it violate PDPA? I think the question here refers to the personal information of the lecturer, and the lecturer is taking objection to this, right? I mean, if the company, or rather the school or university, is implementing online study groups and all these WhatsApp chat groups is commonly used now in place of classroom, physical classroom, then the employer being the university and the school, has to communicate with the lecturers and get their input and consent on the use of these platforms, right? And the sharing of their phone numbers and all that in a WhatsApp group, that has to be communicated. So to me, I think it's so common now. It's part of the business tool. I think it'll be difficult for lecturers or even students to disagree to the use of a WhatsApp group, any platform that makes the studying, communication and all that easier. So I don't think, I mean, the requirement for consent should be there, but I don't think it's something that the school or the university cannot overcome due to the PDPA. It will be part of the business requirement to need to use these platforms. Yeah.
There's another question. Maybe this one is for Mr. Vishnu. Are they covered by SOCSO for any injury due to working from home? For example, laptop fell on foot or something.
Okay, I believe SOSCO department has issued a circular or some guidelines on this issue. So they will take into facts of the circumstances into consideration, namely, sorry, has there been any policy or is it an official work from home that the company practices? So there's a need for the employee to prove that he was officially working from home. He was assigned to work from home on that particular day the accident happened, and obviously the facts of the accident itself, was it somehow work related? So they have issued some guidelines on these issues because end of the day they have actually stated that the social coverage covers while you work from home during work hours as well. So the coverage is there. It's just that whether your claim is successful or not depends on the facts, like I mentioned. Hello? So any further questions from Ms. Wong or myself? I'd rather Ms. Wong answered.
Okay, I think this one for Ms. Wong. If staff is currently WFH, can the company then ask the staff to work in the office?
Yes, of course. I mean, the choice of whether to work from home or to operate from the office belongs to the employer, right? So it's no different from when the employer wants to transfer you from one branch to another branch or from one location to another. So now you are temporarily transferred to work from home, right? And then when you are done with working from home, the employer can instruct you to come back to the office. So I think that is not an issue. The employer can ask the staff to come back to work in the office if that is what is required. Yeah.
Another question is, sending a show cause letter or reprimand letter via email to staff is acceptable?
Sending a show cause letter by email, I think it's very common now, right? Whether it's acceptable or not, of course, boils down to, can you be sure that the employee has received that email? Because the most important thing about a show cause letter is to give the employee sufficient time and notice for him to answer to the show cause letter. So if you have sent the email, he doesn't know, he didn't check his email, and then 2 weeks later you terminate him because he didn't reply to the show cause letter, then of course then the burden is on the employer to prove that that email was received and read by the employee, right? But otherwise, I don't see a problem in this day and age for people to receive communication through email, especially if that has been the norm, right? If you have used the email a platform as a usual mode of communication, then that is not a problem, I think. Anything else?
I missed the question. Okay, there's another question. If we are WFH, can we work from other places such as balik kampung but still working? Any implications?
You see, this is very important. That's a very good question, Shima. The company has to set clear guidelines on this work from home. And you know, as I said just now, this work from home is slowly evolving into WFA, work from anywhere, right? So you need to really set guidelines in your SOP. If you want the employee to strictly only work from home in his home in Klang Valley and not balik kampung, then you have to state that, because maybe there's a requirement for the employee to come to the office on certain days on an urgent basis. And then if he's in his kampung in Kuala Pilah, then that takes too long or too far for him to come back, right? So that the policy has to be clear, okay?
Next question is, while WFH, we send warning letter through email, but employee refused to sign warning letter. Is the warning letter valid?
Okay, so the problem with signing and all that is it can't be done when the person is working from home, right? So the acknowledgement has to come from the employee that they have received that email, and if the employee is being difficult about acknowledging receipt of that email of the warning letter, then I think you have to take more drastic measure. For example, going to his house and getting him to sign the copy of that warning letter. You have to employ your dispatch or your clerks to go and deliver the letter, right? But otherwise, an email, I don't know, some companies you have acknowledgement, right, that the person has read the email. So if you have that function, then that is it's easier to prove that the email has been received. Yeah. I think there's an earlier question that we missed out from the chat group. There's a question that says, can I confirm that an employee should not refuse to come to work due to COVID-19? The short answer is yes, they cannot just simply refuse to come to work due to COVID-19, especially if there is SOP already being complied with by the company, right, in the company's premises, okay? So yes, they cannot simply refuse, and as you have seen the cases that I've shown you, the OSHA provisions and all that, there has to be a real threat of danger. But I have come across a case where a doctor has been asked during the MCO to do COVID-19 tests, and he was not being given the proper equipment, right? So when there is no sufficient protective gear for the doctor himself to come to work to perform all these tests, then of course he is well within his rights to refuse to come to work, right? So it's
How
all
about
about whether there's a real threat.
Okay, sorry, just in lieu of that question, right? How about if the employees mention that, you know, the area of working is a red zone? So because of that, they refuse to come to work. Is that something?
No, I think that's not a valid reason. I mean, if the
Okay.
government has allowed businesses to open in the red zone, right, then certainly employees are allowed to travel into the red zone to work, right? So
Okay.
as long as the company is following the SOP of the Ministry and the Majlis Keselamatan Negara, then I don't think employees can simply refuse, right? But again, ladies and gentlemen, I have to emphasize that we are now in the zaman after COVID, right? You can't really operate just like how you did before about handling cases and all that. Now you have to understand what is this employee's fear, right? And how do you help him cope with that fear? I mean, different people have different levels of fears about their health situations, all right? So like Encik Abu, if he's 55, he's got diabetes, he's got high blood pressure, and then he's got a 90-year-old mother at home, all that is fears to him, right? So there is a need to manage these employees rather than just shut them out, right? So that's what I'm talking about. Of course, in terms of SOPs, you definitely have to follow everything that the government has been advocating, right? Okay, we continue with the questions in the chat.
Last question. As you said earlier, Casey, that WFH staffs are currently working longer hours than normal. Can the staffs claim overtime?
Okay, so overtime is of course dependent on firstly your status, whether you are covered by the Employment Act. If you're not covered by the Employment Act, then it falls back on what is the company's policy, right? If there's no policy for for overtime for executives who are above the Employment Act, then unfortunately no. So again, these are new issues that employers will have to look at, right? If employees are finding that they are working much longer hours, they have to raise that with their bosses and contemplate things like all these extra allowances and overtime, right? But if you're not covered by the Employment Act, then strictly speaking, you're not entitled to overtime. Okay.
Okay, that's one question asking if employees with proper PPE in order to work at workplace, is face mask also considered as PPE? Is it compulsory to provide?
Is it compulsory to provide the face mask at your workplace? I think that depends on the company's own policy and assessment of the risk, because the company themselves, if you don't provide the mask and majority of your employees don't wear a mask, then the exposure level and all that, you may fall foul of the SOP of the ministry, right? Of course, right now, I don't think there's a SOP from the ministry that employers are obliged to pay for the face mask. But really, it's up to the company to assess the risk level, right? And also assess how many people are coming into work and how much social distancing there is and the necessity of providing the face mask. So all that varies from organization to organization, but certainly the SOP now is, I think, to wear the face mask, and that need will certainly arise if employees are not able to cover the cost themselves, then employers may have to do that, right? But it really varies from company to company.
Next question. If staff has UPL for 3 months because of MCO, can staff temporarily working with another company?
Okay, so unpaid leave for 3 months, can you work for another company, right? Can you, or even go and drive a Grab car, or like I said just now, sell cookies and all that? Strictly speaking, if you're on unpaid leave, you are still an employee of the company. You cannot work elsewhere. But that's why I brought up the moonlighting topic just now, right? Because there is situation like this now where employees need to supplement their income because they're on unpaid leave. So where am I going to find income for 3 months if I'm being asked to sit at home for 3 months? So that is where the company needs to be flexible and to come up with guidelines to allow employees to work in a certain way, right? So I'm not saying moonlighting open for all. I'm saying set out your guidelines. What is your guidelines for your employees to work elsewhere or work with another company or work temporarily? Okay.
Okay, last question. Can we claim mobile data charges?
That is something you have to discuss with your employer. There is no what you can claim and what you cannot claim is certainly stated in your policy and your employment contract. So currently, if you don't have it in your employment contract, that's something that you need to raise with your employer. Okay.
Okay, with that said, since that was the last question and we're almost out of time, we'd like to thank Ms. Wong Keat Ching again for her attendance, for her speech, for her lecture, and we've learned so much. We thank you very much. It's been an honor for us to have you, and we'd like to thank all our participants for participating in today's webinar session. We'll be having more webinar sessions in the future, and we will inform you accordingly. Thank you very much, ladies and gentlemen, and see you again.
Thank you. Thank you. Bye-bye.
Goodbye, everyone.
Thank you.